5 big mistakes executors make and how to avoid them. Being named the executor of a family member's or other loved one's estate is in many ways an honor. The decision shows that the person saw you as a highly trustworthy, capable person of integrity. But it is also a major responsibility that can quickly become a burden. That is, if you aren't set up to do your job in a proper way. The fact is, administering an estate comes with plenty of potential pitfalls that can threaten your loved one's wealth and your peace of mind. That goes double if the passing of that person is unexpected and leaves you reeling emotionally as you try to take on the legally required duties of an executor. The good news is that you can take steps to avoid some of the biggest mistakes that executors often make and to ensure that the process goes as smoothly as possible. So first, a few basics. At the passing of a person, everything that person owns becomes part of his or her taxable estate. Estate administration is the process of managing the estate at this time, including paying off debts and any taxes due, and distributing the property to the heirs in accordance with the deceased person's wishes, or by state law if the deceased person did not leave a will. So the executor is the person responsible for estate administration. If you have been named the executor of an estate, you are legally required to wrap up its affairs, arranging for the payment of any income and estate taxes, and distribute the assets of the estate. All too often, though, executors without quality legal guidance make mistakes during the process of carrying out these responsibilities. Mistakes that can expose the estate to litigation, also increase tax liability, and other potentially serious consequences. So let's talk about the 5 mistakes to avoid. So mistake number 1, making distributions too early. See, as an executor, you're liable for the estate and its distributions. If you make a distribution from the estate, handing out money to a family members, for example, before taxes and other liabilities are paid, you're personally responsible. The same is true if you make disproportionate payments to family members. Such distributions are known as at-risk distributions, and they should be avoided. That is not to say you can't make these distributions, but miscalculation or unexpected claim puts you at risk. If, say, you need to get money back from the family member because you have to pay for a tax bill, but that person has already spent the money. Mistake number 2, failing to make the portability election. The concept of portability means a surviving spouse can make use of both his or her individual federal estate tax exemption and the unused exemption of the first to die spouse, because every descendant is allowed a federal exemption of $11.2 million in 2018. This allows a married couple to shelter a combined $22.4 million from any federal estate tax liability. However, the estate tax exemption can often cause problems for surviving spouses when the entire estate of the first to die spouse is sheltered from estate tax. This key requirement is commonly overlooked. That's because you have to ask for it. Even if no estate tax is due upon the passing of the first to die spouse, the executor of the estate must elect portability by filing an estate tax return on Form 706 within 15 months of that person passing away, with the filing of a proper extension, of course. And remember, if you don't use it, you lose it. Mistake number 3, failing to properly advertise the estate. So the appointment of an executor and the existence of the estate may need to be advertised in a local newspaper. If there are debts owed, creditors need to be notified so they can make claims against the estate, if necessary, of course. Each state has different laws that govern the advertisement of an estate. So failure to satisfy a notice requirement may expose you personally to the estate's creditors. Mistake number 4, failing to liquidate securities through a market downturn. As an executor, you would be responsible for managing the estate's assets. That includes any stock portfolio. While you don't necessarily need to have the financial and business acumen of say, Warren Buffett, failing to monitor the markets and estate investments could seriously damage the estate's value. As an executor, you're also a fiduciary, which is someone who is legally required to act in the best interest of the heirs or other beneficiaries of the deceased person, and also to follow instructions that the deceased person spelled out for you. That means it falls on your shoulder to ensure the estate's financial health. That job may involve buying and selling stocks or other securities in response to bull or bear markets. Mistake number 5, failing to properly conclude the estate. So executors who have properly distributed most of the estate's assets often fail to properly close the estate. This may involve filing a family settlement agreement with the court, showing that all beneficiaries agree that they have received their share of the estate, or going through the court accounting process where a judge ultimately approves of the distributions. It is also recommended to work with an accountant or an estate administration lawyer in more complicated cases. That way you can ensure tax matters are concluded before the estate is finished with the administration. So to avoid potential mistakes, there are a number of ways we can help you and direct you during an estate administration. So here are 3 reasons why. Number 1, so you can file the proper forms to protect the estate. So estate administration requires formality with the complex process, applicable statutes, and tax forms. So to protect an estate against costly mistakes, such as, for example, failing to file a state or federal tax return, we can help direct you to navigate the administration process. The second reason, to be protected. There are many actions you take as an executor that can put you at personal risk. To avoid some of these at-risk distributions, we can help you by ensuring that state probate and tax formalities and federal tax laws are fulfilled. We can guide you to the right people that can help you with that. Another reason, to protect the estate value. So if you don't properly protect the estate asset's value, you could be in breach of your fiduciary duty. We here at Confidence Wealth can help you mitigate some of those risks due to market conditions as they change. Also, there might be some other actions you might want to take from an overall planning perspective and investment perspective, such as selling a home or performing an estate sale. And of course, we can help you manage the investment portfolio. So to learn more about estate planning, we did a Q&A with an estate planner. In that session, we've answered commonly asked questions about estate planning, and the link to it is in the description below. See you there.